be able to take care of the assets in a deceased person's name. That executor then takes over, pays the bills, does the taxes, but has to have a court order signed by a judge before he can access the assets. And that's probate. In Florida, statutory recommended probate fee for an attorney is 3%. So if a person had a $500,000 probate estate, that's a $15,000 fee. If they have all those assets in a trust, there's no probate.
Oh.
So the example that you were given, since we didn't mention any names, it was more than a $15,000 savings in that particular case because we avoided probate on all of the assets.
I mean, you know, you don't understand how big this can get. And most people say, well, I don't have that much to worry about. Well, in their mind, it may not be a whole lot.
But you put it down on paper and then start adding it up, it becomes
That's right.
a larger number than you think.
But see, a lot of parents, as they get older, they're afraid to share what they have with their children for fear that it'll be taken away from them or something, you know.
They actually don't have to share it with their children, though. They come see an attorney, get the documents done. I tell my clients, don't give copies of this to your children.
Oh, really?
Because then if you make a change, then you have to explain to the children why you're making a change.
Good point.
So just tell your children where the documents are, and maybe put them in a safe deposit box, give the child a key, but you tell the child, don't go until something happens to me, and you have to sign in most of the time on a safe deposit box, so there's a record of who goes into the box.
That's right.
Don't tell them. It's really none of their business at this point.
Okay, you have all this information on the screen right now. If someone were watching in Hoboken, New Jersey, and they access you, could you help them?
I could help find them an attorney in New Jersey.
Okay.
If they come to Florida, they vacation in Florida, spend 4, 5, 6 months here, and they're in my presence, I can help them. But I can't help them through the mail in another state, but I can help them find somebody. I belong to the National Academy of Elder Law Attorneys. So if someone's interested in estate planning and elder matters, I can find somebody right in their local city. All they have to do is email me.
Okay, let's tackle estate planning. What does that consist of?
Well, estate planning is just recognizing what your assets are and making a plan for what happens to them. Really,
now, you say recognizing.
Well, make a list of your assets. People ask me, what do they need to do when they come see me? Well, I like a list of their assets, just a little one-page summary of what they own. You've got 4 bank accounts, a money market account, a real estate, a vacation home. Just make an itemized, simple list. And then I can go through each one of those assets and tell them if they go in a trust, how they should be titled. They need to know who they want to put in charge of the estate, who the executor or trustee is going to be. And they need to know how they're going to distribute the estate. It might be 10% to their church or favorite charity. It might be 30, 30, 30 to the 3 kids. I need to know. If they want to omit someone, a lot of people think you have to give them $1 or something like that. I usually just put I omit them for personal reasons. And that's unfortunate, but with the way families are, that happens sometimes.
Yeah, I've heard of, which is definitely wrong, but I've heard of families where one child is a millionaire and the other children, are not poor, but they're just making it. And so they don't leave any to the millionaire child, which causes a rift in the family.
Well, I usually say if you love them equally, treat them equally, because the guy that has $1 million today could have a heart attack tomorrow and his business could go downhill and lose it.
That's right.
But the most important thing on estate planning, there are no perfect families. You won't find a perfect family in the Bible even. There just are none. I had a situation where a couple had been married for 60 years. They had 4 children. The oldest one had MS. The next oldest one was drug addicted. The next one was a spendthrift, and the 4th one was Mr. Perfect. They had put off their estate planning all those years because they never knew how to handle these circumstances. And they all require special circumstances. The MS, you want to create, and they love their children equally and wanted to treat them equally. The one with MS, you build a supplemental needs trust so they don't lose government benefits. The drug addiction, you make them go through testing programs before they receive their inheritance over a period of time. If they fail their test, it just gets delayed a year. The spendthrift, you stretch it out so they can't spend it all at once, and Mr. Perfect was going to get his share outright. Wow. But estate planning is taking care of special needs within a family.
That is fabulous.
You know, I never realized that before.
That is fabulous.
Yes, it is.
Yeah.
It is.
You know, I never had one family with all of those circumstances in one family, but I've dealt with those many, many times. So when the client came in, it was a fairly easy solution for me to come up with that. But
what do you do? What do you say to somebody that comes in and says, I've got 2 children. This child has given me nothing but trouble. I want to leave everything to just to one child. Do you?
Well, I honor their request because it's their money and their choice.
But if I know Joe,
well, I might counsel with them a little bit.
Yeah, because you are a great counselor.
Yeah.
I might counsel with them a little bit, but the bottom line is they get people. Circumstances change. So even though they might tell me that, and even though I might counsel them, and even though they might do that, that's not the end of the story yet. Because I can always say, well, I'm going to pray that circumstances change. And you can always change your documents. This is not... Because I've seen, I've seen people omit their children or give them a very small share, and then I face the child after the person dies.
Yes, right.
And they want answers. You know, why did this happen? And why did my parents do this? And it's a heartbreaking thing that affects them for the rest of their life.
Exactly. And how they relate to their own family.
Right.
Have you ever had a Leone Holmesley left all their money to a dog?
Not that much money, but yes.
Have you
I've
really?
had pet statements, and I've had people appoint people to take care of their pets and have a fairly large amount of money set aside for the care of the pets with instructions on the veterinarian and how the dog's going to live and so forth. Yes, I've had cases like that.
Something?
Can there be more than one power of attorney?
You can have as many power of attorneys as you want.
Okay, so if you have an older member of a family that you normally think, well, okay, that'll be the one that determines how to distribute all the wealth.
Well, the power of attorney has nothing to do. The power of attorney is void upon death, so that has nothing to do with the distribution of the assets in the will or trust.
Administrator.
But the power of attorney, before we change subjects, and a lot of people live in Florida. Their children live in 3 different states, and so they might give each one of them a power of attorney because you can have more than one. You can only have your last will is your last will, but on power of attorneys you can have more than one. So if they've given out 3, the first one that can get there to help them has the power to do so, to make health care decisions and things like that. Some kids on the personal representatives or trustees of their estate, they'll make them co, and then the children can decide who has the time to do what when the time comes.
Okay, now the one that is given the ability to distribute the wealth or lack of, whatever, if it's $100 or $100,000, can there be more than one of those per?
Yeah, you can have co-personal representatives or co-trustees.
Okay.
And then they can decide if it's easier for one to serve, then one can resign and just let the other one do it. If they both want to have an equal say in making decisions, then sometimes you put in a tiebreaker just in case they can't agree.
Have you found out that it's best to die poor to keep a happy family than to die rich?
Everybody's different. A lot of people handle money very well, and a lot of people fight over money. And Mark Twain or somebody said you never know a person to share an inheritance with them. I've certainly found that to be true.
Yes.
But every family's a little different.
Now, this is something that, of course, your information, this is where I pull it from. Never too small estate, higher percentage of administrative costs in small estates. That's interesting.
Well,
because we get the idea, I'm so small in my amount of money that I'm going to have when I pass away, forget this whole thing that you're talking about.
Well, every state's a little different, but in the state of Florida, there are 2 main levels of probate. There's a simple level of probate and a formal level of probate. The formal level kicks in when the estate's more than $75,000, and the simple level kicks in on anything under $75,000. But our minimum probate fee that we charge to be involved with an estate, because it's almost the same amount of work, whether it's $10,000 in the estate or $70,000, it's really all the same procedures you go through. We have a minimum fee of $2,500 plus cost. So even if somebody had a $10,000 probate item, the minimum fee is almost $3,000 with the cost involved.
Wow. So
that's
put it
a
in a
30%.
living trust, then you wouldn't have that at all.
If you put the assets in a living trust, there's no probate.
None like that.
Boy, that's a great example.
Yeah.
Now you talk about taking a complete financial inventory.
That's what he
Do
said.
people miss what they think is not of value in their estate?
Well, we give them, just like you came in the other day, I gave you a list of different types of assets and how they should be titled. So checking, savings, money market, CDs, stocks, bonds, all the liquid type of cash assets should